Right now, roughly 700,000 acres of North Carolina farmland, about 3.5% of the state's agricultural land, is owned by foreign entities. In 2026, lawmakers moved to make sure certain countries can never add to that number again. House Bill 133, the NC Farmland and Military Protection Act, signed by Governor Josh Stein on July 7, 2026, becoming Session Law 2026-54 the following day. It passed the House by a stunning 111-2, genuinely rare bipartisan agreement in Raleigh. The bill actually took 16 months to reach that point, working through committees in both the House and a companion bill in the Senate. So what triggered this? Growing national attention on foreign investment in American farmland, especially land near military installations. At the federal level, Congress has been debating similar restrictions, and multiple other states have passed comparable laws in recent years. Here's what North Carolina's version actually does. It prohibits what the law calls adversarial foreign governments from purchasing, acquiring, leasing, or holding an interest in two types of land. First, agricultural land anywhere in the state. Second, land situated within a 50-mile radius of a military installation, including North Carolina's National Guard facilities. That 50-mile number was itself a compromise. The House's original version proposed a 75-mile radius. The Senate's companion bill proposed just 25 miles. Lawmakers ultimately met in the middle. So which countries actually count as adversarial? The law doesn't list them by name directly. Instead, it ties the definition to an existing federal list, the International Traffic in Arms Regulations. In practice, lawmakers and officials speaking about the bill named specific countries currently on that list: China, Russia, Iran, North Korea, Cuba, and Venezuela, among others. It's worth being precise here. The law targets foreign governments and entities they control, not individual immigrants or Americans with family ties to those countries. The bill's sponsor put it directly. This doesn't stop anyone from selling land to any individual person, only to a foreign government considered an adversary to the United States. During debate, some Senate Democrats raised concerns, not about the bill's core goal, but about how broadly that 50-mile radius could reach. One senator pointed out that parts of her own district, more than 50 miles from a major base, would technically fall inside that buffer zone. Other Democrats worried the rule could unintentionally make life harder for longtime North Carolina residents and small business owners who happen to have roots in one of the listed countries, even though the law is explicitly aimed at foreign government control, not individual citizens or immigrants. In the end, those concerns didn't stop the bill. It passed the Senate as well, with broad support across party lines. Now let's talk about what happens to land that's already foreign-owned before this law takes effect. Existing owners who count as a prohibited foreign party can generally keep the land they already hold as of the law's effective date. But they can't acquire any new interest in that land going forward, and they have to formally register their ownership with North Carolina's Secretary of State. Skip that registration, and the penalty is steep. A civil fine of at least $1,000 for every single day out of compliance, which becomes a legal lien against the property itself. There's also a divestiture requirement. If a prohibited foreign party acquires land after the law's cutoff date, or if their country later gets added to the adversarial list, they generally have to sell that land within a set window. To help enforce all of this, anyone recording a new property deed now has to sign an affidavit affirming they aren't a prohibited foreign party. If violations do occur, North Carolina's Attorney General is responsible for enforcement, including using court-ordered receivership to force a sale if necessary. Sections of the law dealing with property acquisition specifically take effect April 1, 2027, giving time for the registration and compliance system to get built. This isn't happening in isolation either. It follows a national pattern. Congress has debated similar restrictions federally, and a growing number of states have passed their own versions of this kind of law in just the past few years. Starting April 1, 2027, adversarial foreign governments and the entities they control are barred from acquiring North Carolina farmland or land within 50 miles of a military base. Existing foreign-held land must be registered, and unauthorized new acquisitions must eventually be sold off, all under the NC Farmland and Military Protection Act. Do you think a 50-mile buffer strikes the right balance between national security and protecting the rights of everyday residents? Or should it have gone further, or not as far? Let us know what you think, and if you learned something new, hit like and subscribe for more breakdowns of the laws shaping North Carolina.